Hi, everyone. In this lesson, we're going to talk about employment, worker protection, and immigration law. All right, so we're going to define term employee and at-will employee. We're going to describe workers' compensation and the benefits available. We're going to describe OSHA. We're going to talk about the Fair Labor Standards Act. We're going to talk about FMLA. We're talking about COBRA. We're going to talk about ERISA. We're going to talk about unemployment systems, unemployment compensation systems by various states. We're going to briefly look at Social Security and then briefly look at immigration laws. One thing to understand as we go into this chapter is we'll go into each of these topics a little bit more deeply in Business 217, which is employment law, which is part of the business major here at Gaston College. You could also take each one of these topics, each one of these learning objectives, and find lawyers who base entire careers on focusing on just that area of law. So what we're going to do is sort of very surface level, high level type understanding, just looking at what things are and just understanding there's way more detail that goes into each one of these topics, but at least we can sort of set the foundation for you to understand the employment and worker protection environment. So, to introduce, the employer-employee relationship is subject to the common law of contracts and agency law. It's regulated by federal and state governments, sometimes even municipal governments. If you have like a city like Charlotte or Mecklenburg County or Gaston County or Gastonia specifically, sometimes they can pass local ordinances as well. But most regulation is going to happen at the federal or state level. We also can break employment down into two major categories. One would be term employment. These are people who are working and they have a contract in place stating that here are the job duties. You're working for a specific period of time. If that person is fired before the contract has expired, then the employer would be expected to pay out the remaining money owed under that contract, unless you find that the employee is fired for cause. In other words, they did something to deserve getting fired, in which case the employer probably wouldn't have to pay out the remainder of the contract. It can get into a messy legal battle at that point with people trying to prove who was fired for what reason. The majority of us, the majority of America, works in an at-will employment environment. That means that an employer is able to terminate the employment relationship, in other words, fire an employee for really any reason that they choose or no reason at all, as long as it doesn't fall into one of the exceptions. There are multiple exceptions to that. And we'll spend just a little bit talking about those exceptions. Sorry for the computer interruption there. All right, so some exceptions to the at-will employment relationship. Well, if you are a member of a labor union, then your relationship to that employer is guided by the union contract that you have. There's a contract in place that states the method and manners in which an employee can be treated or terminated. And then that contract will be the guiding document rather than just at will. You can't just randomly fire a labor union member. You'd have to go through the proper procedures. I should also mention that the flip side of the at-will environment, yeah, sure, an employer can fire you for any reason. From the employee's perspective, an employee can also leave a job for any reason and at any time that they want to without facing any real consequences, especially legal consequences. It is standard in the world that we operate in to give 2 weeks notice, or at least some kind of notice that you're going to be leaving. That is really just something that I do to be courteous, giving my employer heads up a little bit of time to go find somebody else to replace me. It's not legally required. They can't sue me for it. But it's usually a good idea to do because you usually don't want to burn bridges. If possible, you'd like to maintain a good relationship with your previous employers because you might want to use them for references as you go find additional jobs. So that's that at will. I can get a job whenever I want, as long as I can find one and somebody's offering one. I can leave whenever I want. On the other side of that, an employer can hire people and then they can fire them for really any reason, as long as it doesn't run afoul of one of these exceptions. So the labor union exception is one. The public policy exception is another one. So I can't fire somebody because I ordered them to do something unlawful and they refused. When we talk about public policy, we're just talking about things that would contribute to the greater good of our society. There's also a statutory exception. So you can't fire an employee in violation of a federal or state statute, and then you can add local ordinances on top of that as well. One of the main ones we talk about in employment law is the Civil Rights Act of 1964, saying that you can't fire or you can't discriminate against employees because of certain protected classes like race, color, gender, religion, and then we add on things later like disability, pregnancy. So there are certain things that are protected by statute, so I can't discriminate because of those things. But as long as I'm firing somebody just because, if it's just because they're a bad employee, they're not performing, they're showing up late, they're calling out, whatever it is, then I'm probably protected as an employer. So here's a case where a guy got hired. This did happen in California, 2006. But he hired on a job and he signed an agreement saying that he understood that his employment relationship is at will. So they have this document saying he signed, saying that he agreed to an at-will employment environment. What the guy does, Dorr, is he argues that while he was working there, the employer made multiple statements to him, something to the effect of, well, they're not going to just randomly fire him. They would only fire him for a really good reason. So he's probably safe as long as he doesn't mess up, things like that, that people would say in conversation with an employer. Well, he is fired later, and they didn't give him a reason. So he sued, saying that they had made statements or representations and formed sort of like an implied contract by the statements that they made, that he wouldn't be fired. So he thinks he was wrongfully terminated. But as the court looked at it and did go to the Supreme Court of California, but they said, well, ultimately you signed this agreement saying you understood that the employment is at will, so then they can fire you whenever they want, and Dorr loses, the employer wins. So one thing you'll notice as we go through the remainder of the chapter is we take some big, huge area of law, and we try to distill it into a couple of slides here. So workers' comp is a very broad and comprehensive area of law, but the basic idea is if I'm injured on the job, there's a system set up to compensate me that's much easier than trying to sue my employer every time. So prior to workers' comp, if I'm injured on the job, I would have to sue my employer for either intentional injury or some kind of negligence, and have to go through a lengthy court process of trying to prove that my employer was negligent in some way and that contributed to my injury, or at least outright caused my injury. Now we have a workers' compensation program set up it's called a no-fault system, where I don't have to prove that the negligence existed. If I can show that I suffered an injury and I was doing work while it happened, it's much easier for me to file a claim and get compensation. Doesn't happen every time, because some people will try to defraud the system. So you have to be able to screen for that kind of thing. But in general, it's trying to smooth out this process of compensating workers who get injured on the job. So the way you do it is, if you're injured, you would notify the employer, you would file a claim with the agency that handles those claims in your state. In North Carolina, it's the North Carolina Industrial Commission. They have forms on their website you can fill out. The agency will determine the legitimacy of the claim and then pay out benefits accordingly if you're eligible for them. And it can get pretty granular and pretty detailed. For instance, if you lose a finger, if you lose a hand, there might be set dollar amounts that correspond to those types of injuries or those types of losses. If you're injured or disabled in perpetuity and won't be able to return to work again, it might state out a certain amount that you get paid for life or for a certain period of time. So it's often a good idea to retain a lawyer who deals with these types of things, if you can, just to make sure you're protected, because it's hard for anybody to really understand that law unless you're practicing it on a day-to-day basis. So since workers' compensation program exists, employers have to purchase, well, most of them have to purchase workers' comp insurance. So this would be sold by an insurance company who says that, well, there's a certain risk here. We've identified the risk as being a worker who gets injured on the job. So what we're going to do is sell insurance that covers for that risk. Now, if I'm able to convince the Industrial Commission or the state or whomever I'm talking to that I have the ability to pay out claims without having to purchase insurance, as long as they approve me for it, I can actually self-insure. So I wouldn't have to buy insurance. But most companies are going to have to purchase workers' comp insurance just to cover for the potential liability of a worker getting hurt. Because especially small businesses, if a worker gets hurt and it costs a couple $100,000 in medical bills, that's probably enough to sink a lot of very small businesses. So having that insurance in place is pretty important. We do have to show that it's an employment-related injury. The injury arose out of and took place in the course of employment. So it's not something that happened while I'm on my way driving from my house to work or driving from work on my way home. It would have to be I would have to be doing something that's work-related in the scope of employment at the time in order to recover. So it covers for physical injuries, it covers for stress, it covers for mental illness. If I can link that mental illness to the employment environment, it's not always that easy, but it's possible and usually relies on expert testimony. Workers' comp is what we call an exclusive remedy, meaning that once I get a workers' comp claim in, I can't then also sue my employer in court. We would go through the workers' comp program rather than suing my employer in court, unless, here's an exception, unless I can show that my employer intentionally injured an employee. If it was an intentional injury, then yeah, you can sue the employer. Now, that doesn't mean that I can't sue third parties. If I think a third party was responsible for my injury, like let's say there was a piece of machinery that I'm working on and the machinery is defective in some way and I get injured, I could still bring a suit against the manufacturer of that machinery in addition to my workers' comp claim. So it's an exclusive remedy in one way, in that as long as the injury wasn't intentional, I can't sue my employer on top of a workers' comp claim, but I can still bring suit against third parties. This is a case where an employee is working for Walmart, and while she was working back in the stockroom, a big stack of plastic tubs fell on top of her and caused her some pretty significant injuries. An evaluation of her health determined that she was 40% impaired. So she was not completely bedridden, disabled. She was able to be up and walking around, but suffered from chronic headaches and dizziness. And as a result, wasn't really able to go back to work because of the headaches and dizziness and other issues that she experienced. So Walmart was ordered to pay out full disability for her because she wasn't able to come back to work. So Walmart challenges that and says that, well, she was only 40% impaired, so how are we being ordered to pay out full disability? And the ultimate outcome was that the court said that a person doesn't have to be 100% impaired to deserve total disability. The fact that she was not able to return to work was enough to justify the award of total disability. So then Walmart had to pay her. So back in 1970, we're switching gears here now we're going to talk about OSHA. In 1970, Congress at the federal level, federal Congress passed the Occupational Safety and Health Act that was designed to promote safety in the workplace. So as a society, we're coming out of sort of this industrial age where everybody's working in mills, which didn't have a whole lot of protections, could be incredibly dangerous. People were getting injured on the job all the time. And so now what we're doing is coming out of that, we're trying to boost the protections for workers in the workplace, and OSHA, or Occupational Safety and Health Act, is part of that. I keep saying OSHA. OSHA technically is the administration who administers the legislation, but oftentimes I just say OSHA for both. So as they passed the Occupational Safety and Health Act, and this also creates the Occupational Safety and Health Administration, which is OSHA, that people refer to all the time. So this is the federal administration who goes in and inspects workplaces and makes sure that employers are creating and maintaining safe work environments for their employees. So it also imposes record keeping and reporting requirements. So keeping track of when injuries happen, just so we have a record and can look back and see that the employer is fixing things that are causing injuries. It also requires employers to post notices in the workplaces, informing employees of their rights. So the Fair Labor Standards Act does this as well. They require employers to post notices. You usually see these back in like an employee break room. They're usually not posted out where the public sees them. Sometimes they can be, just depending on the physical layout of a store. But oftentimes, if you go back toward bathrooms or somewhere where the employees would have a locker room or a break room, you see these big posters posted up on the wall, informing workers of various rights that they have. So they're interesting to read through. And that's why they're posted up there, is because the laws say they have to. But anyway, OSHA is the federal administrative agency that's empowered to enforce the Occupational Safety and Health Act. Okay, so they can adopt rules and regulations to interpret and enforce the act. And the act isn't big enough to clearly lay out in fine detail everything that qualifies as a safe environment. So what it does is it empowers this administration, the administrative agency, to go in and find out what those things are, and then they can adopt rules and regulations going through a defined process to then enforce the safety laws. So thousands of regulations have been adopted to enforce the safety standards established by the Act. If you're an employer, it can be kind of tedious to have to deal with all these rules. What we hope is that overall it creates a safer society for everybody. Okay, so there's two types of OSHA standards. One is specific duty standards. So now we're looking at very specific jobs, specific procedures, maybe even specific types of machinery, unique work conditions, and saying, well, in these specific circumstances, here's what you have to do to maintain a safe working environment. But not everything fits neatly within specific duty standards. So there's also this general duty standard saying that, well, in general, an employer has an obligation to provide a work environment that's free from recognized hazards that either are causing or are likely to cause or have caused, in the past, serious physical harm to employees. Okay, so there will be regulations on all types of things, like how high can steps be? They have to be uniformly high in most cases, and if there's a step that people wouldn't expect there, it has to be marked with some type of bright tape, and all kinds of rules that you would have to be aware of when you're maintaining a work environment. So this case was a very famous one. They actually made a documentary based on this case. The documentary was called Blackfish. But anyway, it was a very tragic case of a SeaWorld trainer who was killed by the orca whale that she was working with. Upon investigation, we found out that that particular whale named Tilikum had a history of injuring people, and in the past had killed 2 other trainers. And so the family sues, the family of the deceased trainer sues SeaWorld, saying that they did not create a safe work environment for her. SeaWorld tries to defend themselves, saying that they were doing everything that they could. But the end result was that SeaWorld had to put in some additional protections, saying that the trainers had to have safety barriers or safety decking in place and couldn't be in the water with the whales anymore. SeaWorld obviously didn't want that to happen because that was part of their big show, is that the trainers are in their water swimming with the orcas and doing all these tricks and everything. But the court found that this is what was necessary to provide for the safety of the trainers. Okay, the Fair Labor Standards Act, we're backing up in time. So the Occupational Safety and Health Act was 1970. Now we're going back in time to the Fair Labor Standards Act in 1938. So this is the big piece of legislation that establishes a minimum wage, and it establishes overtime pay requirements. Okay, so now we're getting a 40-hour work week. We, as in, the common working public, get a 40-hour work week and a defined federally mandated minimum wage. It also passed a bunch of laws regarding regulating child labor. So again, before this, we're in the industrial age. We have very big industrial mills operating. It's common for children to be working there. It's common for employers to want employees to work 6 and 7 days a week, insane work hours, very dangerous conditions. So now the federal government is stepping in and trying to regulate this and make it safer and better for the workers. There are always going to be arguments over the minimum wage. It's just a controversial thing. We see those arguments persist to today. The federal minimum wage at the moment is $7.25, which I'm not aware of very many people paying that low. But if you back up a couple years, it was pretty common to find employers who were paying that low minimum wage. Now there's a labor shortage at the moment. This is 2022 and I'm recording this, and we're coming out of COVID, and there's been some supply chain shocks and all kinds of crazy things that have been happening in the economy. So the labor market is very tight. So most employers are paying more. But if all that stuff gets ironed out, we might find that employers start paying less and get down to the minimum wage again. We'll just have to wait and see what happens. But anyway, the FLSA is what spells all this out. Department of Labor regulations for child labor. This is the federal level. So if a person is less than 14, they can be newspaper deliverers. I don't even know how much of a deal that is anymore. I would imagine the number of newspaper deliverers has gone dramatically down from 20 or 30 years ago. If you're 14 to 15, you can do non-hazardous jobs, and you're limited on the hours. The understanding being that we're trying to, for school-aged children, you shouldn't require them to work beyond some period of time at night because they need to go home, do their homework, go to bed, and be able to go to school the next day. Between 16 and 17, they can still only do non-hazardous jobs, but then the hours aren't as limited. And then 18 and beyond, you're able to do any job, any hours. You're considered to be a legal adult at that point. North Carolina, if you look into North Carolina laws, we have our own set of laws, and it gets a little bit more detailed as far as at what time can a person between the ages of 14 and 17 work, because again, they need to be in bed so they can go to school the next day. Okay, so we talked about the minimum wage a little bit. Non-exempt employees have to be paid the federal minimum wage for all hours worked. And if you work over 40 hours in a week, then you have to be paid 1.5 times. Oftentimes people just say time and a half of whatever the regular hourly rate is for every hour worked over 40 for that week. And then there are a lot of exceptions to that. But if you're an hourly employee, and as long as you don't fall into one of the exceptions, then if I work over 40 hours for a week, I have to be paid time and a half for those hours over 40. We can talk, I struggle with some of the exceptions. Let's talk about a few of the exceptions. So I'm not going to go into all of them, but oftentimes these laws allow for students and apprentices to be paid less than the minimum wage. How often that happens, it's kind of hard to tell, especially with the tight labor market like we have right now. I would venture to guess that most employers aren't able to get away with paying less than minimum wage because you wouldn't be able to find anybody who would work it. But again, we'll just have to see as the economy sort of stabilizes and normalizes. People like first responders, police officers, firefighters would be required to be paid overtime regardless of their rank or pay level. That's only significant because when we learn about, I'll just go to the next slide. As we learn about non-exempt employees, these would be non-exempt employees are the ones that have to be paid minimum wage and overtime. Those are blue collar workers. White collar workers would be called exempt employees. So exempt employees are salaried workers. So as long as I'm making a certain dollar amount, I'm meeting some certain dollar amount threshold. And in 22, that threshold is $684 a week, which translates into about $35,500 annually. Then I could be considered an exempt employee, and thus they can require me to work over 40 hours without paying me any extra, and then I'm not able to go in and claim that overtime. So we're usually talking about management level people or above in that category rather than the lower level hourly employees. So this lists a few types of exempt employees. Again, if you read the legislation, it gets very detailed, but we're talking about executives, administrative employees, learned professionals, highly compensated employees, computer employees, outside sales representatives, and then teachers. Much to the chagrin of many K through 12 teachers who find themselves working way beyond 40 hours a week in a given school week, they're not eligible for overtime pay. Mm-hmm. So minimum wage overtime applies to those lower level hourly employees. Once you get up into a salary position, as long as you're making roughly in 2022 $35,000 a year, then you're not eligible for that overtime. Okay, FMLA, the Family and Medical Leave Act. This is America's attempt at passing some type of, it used to be called maternity leave. Now it's more common for us to refer to it as parental leave, saying that at least the impetus of it, the origin of it was saying, well, a lot of countries out there have paid maternity leave. If a person has a baby, then they need a specific or at least some period of time to stay at home and try to take care of that baby until the baby's able to be sent to daycare or somebody else can come take care of it. Give time for the mother to recover from the birth process. And, this again is controversial. People oftentimes say that America is the only industrialized country who doesn't have paid leave. And for the most part, they're correct, because FMLA is unpaid leave. It is a federal act. It guarantees workers up to 12 weeks of unpaid leave in a 12-month period to attend to family and medical emergencies and other specified situations. So it's not only pregnancy and childbirth that's covered under FMLA. It's really any kind of medical emergency or other type of situation that I would need to take that leave for. But there are a lot of caveats here. It only applies to companies that have 50 or more employees. It applies to federal, state, and local government workers. So if I'm working with a small business who has fewer than 50 employees, then I really don't have any FMLA coverage required. Now, that employer might choose to offer maternity or paternity or parental leave or whatever they call it. They might choose to, and it's usually a smart idea to recruit and retain good workers, but they aren't federally required to. And another caveat, so 50 or more employees, and the employee must have worked at the company for at least 1 full year before they can claim this FMLA leave. Now, having said that, just like I said a second ago, oftentimes employers will choose to offer better benefits. They might say, well, you get up to 12 weeks of paid leave instead of unpaid. Or they might even go beyond that and offer more time, maybe less time. If they offer less time, it can be paid leave, but then they would have to still at least meet the 12-week requirement under federal law, and the remaining being unpaid. There are a lot of ins and outs of this, but that's the basic idea behind it. So what can I use it for? Well, like we discussed, the birth of a child, placement of child for adoption or foster care, taking care of some type of serious health condition, and also to be able to care for a spouse, child, or parent who has a serious health condition. And the law provides that while I'm gone, when I return, I have to be restored to either the same position or an equivalent position when I come back. So they can't just fire me if I'm claiming FMLA leave. I have the ability to come back and get my job back, and they have to place me either in the same position that I had before or one that's equivalent with equivalent pay and hours and stuff like that. If you've ever left a job or been fired from a job before, you may have received a notice notifying you of your rights under the Consolidated Omnibus Budget Reconciliation Act, and then we just shorten that to COBRA. What this is a federal law that permits employees and their beneficiaries to continue their group health insurance after an employee's employment has ended for a period of time. So if I have, some type of illness and it requires a lot of money to take care of, it's probably worthwhile for me to pay. What I'm going to have to do is after my employment has ended, I would have to pay out of pocket for the full cost of whatever that healthcare program is that I had with my employer. And that can be very expensive. But for some people, their health care needs are also incredibly expensive. So for them, it's oftentimes very valuable to pay for COBRA for as long as it takes for me to get another job. Now, it's not going to continue forever, but at least for a temporary period of time, I can pay under COBRA to retain my health insurance benefits until I can find other health care somewhere else. I'm usually going to want to find health care somewhere else because COBRA, again, if you're paying the full cost of that health insurance premium, it can be pretty expensive. Shifting to another law, the Employment Retirement Income Security Act, also known as ERISA. This is a federal act designed to prevent fraud and other abuses associated with private pension funds. Okay, so we found out that some companies were not exercising a lot of judiciousness in their handling of pension fund money. So sometimes companies were just raiding the pension funds to pay for their own debts or to pay bonuses for executives or whatever. And so then people who thought that they had this big fat pension fund that they were going to retire on that was funded by their company found out later on that money was just not there anymore. So Congress passes ERISA to try to prevent some of those kinds of abuses. So employers are subjected to record keeping and disclosure requirements. They have to put this money in under the trust of somebody else, of a third party, to manage it. And it has to be managed for the benefit of employees. It can't be for the benefit of the company anymore. It also provides for vesting requirements. What vesting means is that if my employer is contributing money into my retirement fund, it could be a pension fund, it can be a 401k, it can be, whatever. It can be it can be a defined benefit or a defined contribution fund. But if my employer is contributing to that, when does the money become mine rather than the employer's? So the vesting requirements under ERISA give a specific timeline for when those benefits are vested, to where the employer can't the employer can't claw them back, and they become the employees, unable for the employer to get them back. The money that I contribute myself is always mine, and my employer never has any rights to that money at all whatsoever. Okay, so talking about unemployment compensation, many of you maybe have experienced this before. There's been a lot of economic turmoil, even in my lifetime, and I'm not really that old, but I saw the stock market crash in the dot-com bubble burst in the early 2000s. I saw the financial crisis in 07, 08, 09, and then we're experienced COVID and all the stuff that goes along with that. But if I lose my job, most states, well, I guess every state has to have some type of system for unemployment compensation. Now, it's not always a good system. There are a lot of criticisms that can be thrown around, but the basic idea is that employers have to contribute into an unemployment compensation fund. And if somebody is fired or laid off, then that worker can apply for unemployment compensation for the period of time that they're unemployed, with a lot of limitations. There's going to be limits on the amount of money that they can claim. There's going to be a limit on the amount of time that they can receive those benefits. And there's a lot of bureaucratic red tape that goes along with it. But that's the basic idea, is to provide some type of safety net for a worker who is either fired or laid off, to at least receive some base level of income to hopefully keep them stable enough for them to go find another job without losing their house and everything that would come along with just being completely without income for a long period of time. I have to meet certain requirements. I can't be, if I'm fired for cause, then I'm probably not going to be eligible. But as long as I meet the requirements, then I can apply and potentially receive unemployment compensation. So like I said, each state has their own system. Some systems are better than others. And, during the COVID process and in the financial crisis, we saw that a lot of states were just not adequately prepared to handle the amount of claims that came in. There was a lot of backlog. People were stuck waiting a long time to get the compensation that they frankly deserved. But that's the way things are. And hopefully we would hope things would get better. But ultimately it's very political, and whoever's in charge of running the government at that time has a big say in, how well is the unemployment process going to run. But anyway, to collect benefits, an applicant has to be able to work. They have to be available for work. They have to demonstrate that they're actively seeking employment. They can't have been let go for bad conduct, i.e. fired for cause. And they must have not quit without just cause. So as long as I can show all those things and show that I'm eligible, then I can potentially receive those benefits. Just a brief discussion about Social Security. This was passed way back in the early 1900s, but it provides for this, again, a social safety net for retirees. Was maybe one of the biggest intended beneficiaries under the Social Security system, but also for survivors, for people who are disabled, and for Medicare benefits. So what you often notice when you're looking at your pay stub is you have your gross pay up here, then you have all these deductions, and you get your net pay, which always seems too low compared to what your gross wages are. So part of the money that comes out is Social Security and Medicare. So Social Security, the employee pays 6.2% of your wages into the system. Your employer also pays 6.2%. So 12.4% of your gross earnings are being paid into the Social Security system each pay period to try to help fund this system. Medicare is 1.45%. Again, 1.45% paid by the employee, 1.45% paid by the employer, and all this money goes into the system to help fund Social Security payments for retirees and for disabled people and for people who are on Medicare, which is the retiree healthcare benefit run by the government. obviously I'm required as an employee and an employer to pay into the system. Small businesses oftentimes get themselves into trouble because they just aren't paying attention to this. They're just focused on trying to get their business up and off the ground and running, and they're not paying attention to the fact that they have to pay Social Security benefits or Social Security tax payments for their employees. So it's definitely something to be aware of if you're going to go out and start your own business. Now into a brief discussion about immigration law. Again, a very comprehensive area of law, very political right now. And I guess it always has been. Immigration is always going to be a political football that one party or another chooses to use for their own purposes. But a couple things to understand going in. Immigration is primarily governed by federal law. It's administered by the U.S. Citizenship and Immigration Services, the USCIS. There is an employment eligibility verification obligation that employers have. They have to obtain a completed I-9 form from every employee, which is the employee stating that I am a U.S. citizen or I'm otherwise eligible to work in the United States, because you're supposed to verify that every person that you hire is eligible to work in the United States. Either you're a U.S. citizen or you have some type of visa or some type of certification from the government that states you're eligible to work and earn wages in the United States. The idea was to provide punishment for, there used to be a system where it was illegal for a worker who's undocumented to work in the United States, but the employers who hired them didn't suffer any type of regulation at all. So then, the Immigration Reform and Control Act was passed in the 90s, supposed to try to close that loophole and provide for penalties for employers who knowingly hire undocumented, ineligible workers in the United States. Having said all that, there are various types of visas that foreign workers and domestic employers can use to try to hire non-U.S. citizens legally to try to cover themselves. So a B-1 visa issued to a person seeking temporary entry to U.S. for business purposes, a B-2 for tourism and non-business purposes, an F-1 visa for somebody who wants to come to the United States to study, to attend college or university here, an H-1B visa for foreign workers who are skilled in some type of specialty occupation, EB-1 visa for people who demonstrate extraordinary ability for certain types of employment. So you can think like athletes or scientific researchers or some type of high-level C-suite manager for a business, an EB-5 visa for people who invest a certain amount of money in a commercial enterprise that's located in the United States and also meet other requirements. And then we have H-2A and H-2B visas, which are maybe the ones that we hear about most often. The H-2A permits employers to bring in foreign workers to perform agricultural work, and the H-2B is for seasonal work that's non-agricultural. So bringing in people not to become U.S. citizens, not for them to stay here forever, but for them to come in and perform some type of specific job or for a specific season before returning back home. Okay, so we've very broadly brushed a lot of areas of very complex U.S. law here regarding employment. Again, you can do a super deep dive into any one of these topics. And if you're interested in it, go for it. I'd be interested to hear what you find out. If you want to learn more, in Business 217, we talk way more about the Civil Rights Act of 1964, FMLA, the FLSA. We hit on a lot of those and go in more detail. So, you'll learn more in those classes. But for now, for the purposes of this class, that'll be enough. If you have questions, let me know. I'd love to have a conversation with you. Otherwise, have a great day.